Employment law in Vietnam. Vietnam has a civil law system which has evolved to include some common law elements. For example, the Supreme Court has issued a resolution to the effect that precedents will be used in Vietnamese courts. Vietnamese employment law is very prescriptive and generally very employee-friendly. Terminations must be based on statutory grounds and are subject to strict formal requirements and procedures. The core law regulating the employment relationship is the Labor Code. Employment is further governed by a range of government regulations, decrees and circulars. There are three types of contracts: an open-ended contract, a fixed-term contract of between 12 and 36 months, or temporary contracts of fewer than 12 months, generally for a particular assignment or seasonal work. Fixed-term contracts may be renewed only once, and a second renewal automatically turns the contract into an open-ended one. Employment can be full-time or part-time. Dispatch or agency-type arrangements, sometimes referred to as labor leasing, are only permitted for a limited number of specified roles and only for up to 12 months. Like in other countries across Asia, this area is highly regulated. Regulations of employment contracts. Parties are generally free to negotiate their own terms in employment contracts, provided that mandatory terms as required by the code are included and the contract does not include any terms less favorable than those prescribed by law. An employer must enter into a contract with the employee before the start of their formal employment. Contracts must generally be made in writing except for temporary work of less than 3 months, in which case an oral contract may be used. It is recommended that the contract is in Vietnamese. However, if the employee is not a Vietnamese national, then the contract may be dual language. Probationary periods of up to 60 days are allowed for jobs that require high-level specialized or highly technical skills, for example, roles that require at least a tertiary degree, or up to 30 days for intermediate-level specialized or technical expertise. Probationary period also can last right up to 6 working days depending on the roles. Employees may be paid a reduced wage during the probationary period, but this must be at least 85% of the full wages for the relevant position. Either party may terminate the contract during the probationary period. In addition to the employment contract, employers with 10 or more employees must have written internal labor rules in place. Internal labor rules will govern matters such as working hours, rest periods, and disciplinary processes of an employee. An employer is required to consult with the trade union over the contents of internal labor rules before finalizing them. The internal labor rules must be registered with the local labor authority. Terminating employment. Termination of employment is strictly regulated. At will, termination is not permitted. Given the difficulties associated with terminating employment, it is common for parties to agree mutually to terminate employment. An employer is restricted by law in the sanctions it can issue for disciplinary offenses. It may only issue a reprimand, warning, a pay freeze for up to 6 months, demotion, or dismissal. Grounds on which employers can terminate for disciplinary reasons are set out under law and include matters such as theft or embezzlement, deliberate violence causing injury, and absence without leave. Strict statutory disciplinary procedures must be followed in order to effect a lawful dismissal, for example, regarding the notice and conduct of the disciplinary hearing. In addition to dismissal following a disciplinary process, an employer may unilaterally terminate employment for reasons such as the employee being ill or injured or unable to work, despite treatment, for a period of 12 consecutive months where the employee has an open-term contract. An employer must give at least 45 days notice to an employee on an open-term contract. Each redundant employee who has worked for the employer for 12 months or more is entitled to a redundancy allowance equating to at least 2 months' pay. A pregnant employee is normally entitled to take 6 months paid maternity leave. An employee gives birth to more than one child at one time, she is entitled to take an additional 30 days paid leave for each additional child. If a woman is in her 3rd trimester of pregnancy, she is not permitted to work at night, work overtime, or take business trips. A female employee can't be subject to labor discipline while pregnant, during maternity leave, or while nursing a child under 12 months old.